The air in the congressional hearing room was thick with anticipation on a crisp morning in Washington, D.C. Rows of polished wooden chairs were filled to capacity with journalists, aides, and spectators, their murmurs creating a low hum that underscored the gravity of the moment. At the center of the room sat Supreme Court Justice Amy Coney Barrett, her black judicial robe a stark contrast to the polished witness table before her. At 51, Barrett was the youngest justice on the Supreme Court, her composed demeanor and sharp intellect a hallmark of her rapid rise through America's legal elite. Yet today, her expression betrayed a flicker of frustration. Her lips pressed into a thin line as she faced the House Judiciary Committee. Across from her, elevated on the dais, sat Representative Jasmine Crockett, a 42-year-old Democrat in her second term representing Texas's 30th congressional district. Crockett's bright yellow blazer stood out among the sea of dark suits, a visual declaration of her bold presence. Her microphone rested lightly in her hand, but her posture, leaning slightly forward, signaled she was ready for battle. Moments earlier, she had concluded a series of pointed questions about the Supreme Court's recent 6-3 decision in Johnson versus Pennsylvania Election Commission, a ruling that narrowed the scope of Section 2 of the Voting Rights Act, limiting federal courts' ability to intervene in state voting restrictions disproportionately affecting minority voters. The tension between the two women had been simmering for months. Barrett, a staunch originalist and textualist, had joined the majority opinion, penned by Chief Justice John Roberts, which argued that disparate impact alone was insufficient to prove voter discrimination. Crockett, a civil rights attorney before entering Congress, had publicly criticized the decision, arguing it eroded protections for minority voters. Her questions during the hearing had grown increasingly sharp, probing Barrett's judicial philosophy and the real-world consequences of the court's rulings. The committee chairman, a seasoned lawmaker with a reputation for maintaining order, adjusted his glasses and announced, "The chair now recognizes the gentlewoman from Texas, Ms. Crockett, for 5 minutes." Crockett leaned toward her microphone, her Texas accent measured but firm. "Thank you, Mr. Chairman. Justice Barrett, thank you for appearing before us today." Barrett nodded politely, her hands folded neatly on the table, her expression neutral but attentive. "I'd like to discuss the court's recent decision in Johnson versus Pennsylvania Election Commission," Crockett continued. "In that case, the court effectively limited the ability of federal courts to intervene when states impose voting restrictions that disproportionately affect minority voters. Is that a fair characterization?" Barrett leaned forward slightly, her voice calm but precise. "Congresswoman, as you know, I cannot comment on specific cases beyond what's in the written opinion. The decision speaks for itself." Crockett nodded, undeterred. "I understand, Justice Barrett. Let me approach this differently. During your confirmation hearing, you described the Voting Rights Act as a super statute and extremely important. Do you still hold that view?" "Yes, I do," Barrett replied. "The Voting Rights Act was landmark legislation." "Yet in Johnson, you joined an opinion that significantly narrowed its application," Crockett pressed. "The majority opinion stated that disparate impact alone is insufficient to prove discrimination. How do you reconcile that with the original intent of the Voting Rights Act to protect minority voters?" Barrett's posture stiffened, though her expression remained composed. The opinion carefully examined the text of Section 2 and relevant precedents. Our job is to interpret the law as written, not to achieve particular policy outcomes. Crockett glanced at her notes, then looked directly at Barrett. Justice Barrett, are you aware that in the 6 months since your decision, 7 states have enacted new voting restrictions that have been shown to reduce voting access in predominantly Black and Hispanic neighborhoods? Congresswoman, I don't follow legislative responses to court decisions in that level of detail, Barrett responded. Policy consequences are for Congress to address. The court's role is limited to determining what the law requires. Crockett leaned forward, her voice steady but laced with urgency. With respect, Justice Barrett, is it important for justices to understand the real-world impact of their decisions on American citizens? These aren't abstract legal theories. These are people's fundamental rights. The room grew quieter, the weight of Crockett's words settling over the chamber. Barrett's response was measured but firm. The court cannot base its decisions on desired outcomes rather than legal principles. That would undermine the rule of law. We must apply the Constitution and statutes as written, even when the results might not align with what some consider optimal policy. Crockett removed her glasses, her eyes locking onto Barrett's. Justice Barrett, before your confirmation, you published an article suggesting that Section 2 of the Voting Rights Act was constitutionally questionable. Yet, during your confirmation hearing, you refused to acknowledge this view. Why should Americans, particularly those from minority communities like mine, trust that you're approaching these cases with an open mind? A murmur rippled through the room. Several Republican committee members shifted uncomfortably, and the ranking member raised his hand to object. The chairman glanced at his watch, but Crockett pressed on. She displayed a large chart showing county-by-county data on polling place closures. Justice Barrett, these red dots represent polling places closed in majority-minority districts since your ruling. The blue dots show new polling places opened in majority-white districts. This pattern has emerged in multiple states. Does this concern you at all? Barrett took a deep breath, her voice steady but her patience visibly thinning. Congresswoman, I cannot comment on matters that may come before the court. If those policies are challenged legally, they could reach the Supreme Court. So, you're unwilling to acknowledge the direct consequences of your decision? Crockett pressed. I'm following a long-established practice of not commenting on potential future cases, Barrett replied, her tone cooling noticeably. Crockett's next question cut deeper. Justice Barrett, you have 7 children, including 2 Black children you adopted from Haiti. How do you explain to them that you participated in decisions that make it harder for people who look like them to vote? The room erupted in murmurs. Several Republican members objected immediately. Mr. Chairman, this line of questioning is inappropriate and personal, the ranking member shouted. The chairman hesitated, then said, the gentlewoman should be mindful of the line between professional and personal matters. Barrett's composed demeanor finally cracked. Her face flushed as she leaned toward the microphone, her voice uncharacteristically sharp. Congresswoman Crockett, perhaps you should go back to your hood, where these performative tactics might actually impress someone. This is the United States Congress, not A political rally? A collective gasp echoed through the chamber. Camera flashes erupted as photographers captured the moment. Democratic committee members looked stunned, while several Republicans shifted uncomfortably in their seats. The chairman banged his gavel repeatedly. "Order! Order in the committee!" The chamber fell silent as Representative Crockett slowly rose from her seat. Instead of the explosive reaction many expected, she stood perfectly still, her expression calm but resolute. When she spoke, her voice was measured, clear, and resonant, cutting through the tension like a blade. "Justice Barrett," Crockett began, "I grew up in a military family serving this nation. My father wore the uniform of the United States Army for 30 years, defending the Constitution you're sworn to uphold. My mother worked as a public school teacher in communities across this country. My hood, as you call it, was on American military bases where families of all backgrounds served together." She paused, letting her words settle over the silent chamber. "After that, my hood was the classrooms of Rhodes College, the same institution where you studied. Then it was the halls of the University of Houston Law Center, and later the courtrooms of Texas, where I represented citizens whose constitutional rights had been violated." Crockett picked up a worn copy of the Constitution from her desk, holding it up for all to see. "Now, my hood is this chamber, where I took the same oath you did to support and defend the Constitution of the United States against all enemies, foreign and domestic. I didn't come here to impress anyone. I came here seeking answers for the American people who are witnessing their fundamental rights eroded, decision by decision." The room remained utterly silent, every eye fixed on Crockett. "Justice Barrett," she continued, her voice gaining strength without rising in volume, "your comment reveals exactly what millions of Americans fear, that those with the power to interpret our Constitution view some American communities as less worthy of respect and protection than others, that some neighborhoods, some hoods, are seen as beneath consideration when making decisions that affect every citizen's rights." In an unexpected move, Crockett stepped down from the dais, walking to the chamber floor closer to Barrett's table, still holding the Constitution. "I'm not offended by your suggestion that I return to my hood," she said. "I'm deeply concerned that a justice of the Supreme Court would use such language while defending decisions that demonstrably harm the voting rights of Americans in those very communities." She held up the Constitution again. "This document doesn't recognize hoods. It begins with 'we the people,' all of us. It doesn't distinguish between Americans based on where they live, how they speak, or what they look like, and neither should those sworn to interpret it." Several committee members began to applaud, but Crockett raised her hand. "I'm not finished," she said firmly. The room fell silent again. "Justice Barrett, I have a proposal. Since you referenced my hood, I invite you to visit my district in Texas. Walk the neighborhoods. Meet the voters who waited 5 hours in line during the last election because polling places were closed. Speak with the community leaders working to register voters despite new restrictions. See firsthand the impact of the court's decisions on real American lives." Barrett's expression shifted, a mixture of surprise and discomfort replacing her earlier indignation. Crockett continued, her voice unwavering. "This isn't about scoring political points. It's about ensuring that the highest court in our land understands the lived experiences of all Americans, because justice cannot be blind to reality, even as it remains impartial in its application of the law. Crockett returned to her seat, her final words echoing in the chamber. "My time is expired, Mr. Chairman, but I sincerely hope Justice Barrett will consider my invitation. The people of my district, my hood, would welcome the opportunity for their Supreme Court to see them as the Americans they are." The chairman, momentarily speechless, finally managed, "The gentlewoman's time has expired." The room erupted in applause, not just from Democratic members and spectators, but from many Republicans as well. Even journalists, typically neutral, seemed moved by the exchange. Barrett sat motionless, her earlier comment now overshadowed by Crockett's powerful response. Within minutes, video clips of the exchange spread across social media like wildfire. The hashtag #MyHoodIsAmerica trended nationwide, with citizens sharing stories about their own communities and what representation meant to them. Major news networks ran the footage on a continuous loop. CNN's chief legal analyst remarked, "In my 30 years covering the Supreme Court, I've never witnessed an exchange as revealing about the cultural and experiential divides that influence our justice system." By evening, the clip had been viewed over 10 million times. 48 hours later, Justice Barrett did something unprecedented for a sitting Supreme Court justice. She issued a public statement. "My comment to Representative Crockett was inappropriate and beneath the dignity of the office I hold," the statement read. "While I disagree with the nature of the questioning, my response failed to reflect the respect due to a member of Congress and the community she represents. I sincerely apologize." The statement continued, surprising many court observers. "After reflection, I have decided to accept Representative Crockett's invitation to visit her district. Understanding the real-world context in which our decisions operate can only strengthen the court's ability to uphold constitutional principles for all Americans." The announcement generated headlines across the country. Legal scholars debated whether Barrett's planned visit represented a vital step toward bridging the divide between the court and the public, or a risky blurring of the separation of powers. Former Supreme Court Justice Stephen Breyer commented, "Throughout our history, the court has evolved in its understanding of how constitutional principles apply to changing social realities. Direct engagement, properly conducted, can inform without compromising judicial independence." 3 weeks later, Barrett arrived in Texas's 30th Congressional District. Her visit, carefully structured to avoid political appearances, included meetings with community leaders, local judges, election officials, and ordinary citizens. No cameras were allowed, but participants described the meetings as substantive and respectful. A local pastor told reporters, "Justice Barrett listened more than she spoke. She asked thoughtful questions about how recent voting changes affected our community. Whether this changes her judicial philosophy, I can't say, but she genuinely wanted to understand our experiences." For Crockett, the aftermath brought both praise and heightened responsibility. She appeared on several national news programs, but consistently redirected the conversation away from personal conflict toward substantive issues. "This isn't about me or Justice Barrett," she said during one interview. It's about ensuring our democracy works for everyone. The Constitution begins with "We the people" for a reason. That includes all of us, from the highest chambers of government to every neighborhood in America. The exchange sparked a national conversation about the relationship between abstract constitutional principles and lived American experiences. Law schools reported record applications from diverse candidates, inspired by Crockett's defense of constitutional rights. Community forums on constitutional issues sprang up across the country, many using the Barrett-Crockett exchange as a starting point for discussion. 6 months later, the Supreme Court heard arguments in another voting rights case. Court watchers noted that Barrett's questions during oral arguments seemed more focused on how legal standards would function in practice, not just in theory. While her vote remained unpredictable, the tenor of her engagement had subtly shifted, reflecting a deeper consideration of real-world implications. A year after the confrontation, Harvard Law School hosted a remarkable event, a public dialogue between Barrett and Crockett on constitutional principles and lived experiences. The auditorium was filled to capacity as the two women, who had clashed so memorably, engaged in a substantive discussion about how the court and Congress could better serve the constitutional rights of all Americans. Barrett acknowledged, "My legal training emphasized textual analysis and original meaning. Those remain essential tools, but I've come to appreciate more deeply that constitutional principles must function effectively in the real world if they are to fulfill their purpose." Crockett responded, "And I've gained greater appreciation for the court's institutional role and the importance of principled legal reasoning. The Constitution needs both faithful interpretation and meaningful application." The exchange that began with "Go back to your hood" had evolved into a model for how Americans with profound differences could engage in difficult conversations about justice and democracy. As one constitutional scholar wrote in The Atlantic, "When Barrett insulted Crockett, she inadvertently revealed a divide in American life that goes beyond legal philosophies to questions of whose experiences count in our constitutional system." When Crockett responded with dignity and invitation, rather than rage, she created space for something rare in our polarized era: genuine dialogue across difference. The confrontation between Justice Barrett and Representative Crockett became more than a viral moment or political scandal. It became a case study in how conflict, when handled with wisdom and respect, can lead to greater understanding. Their exchange reminded Americans that democracy requires both institutional integrity and human connection, that constitutional principles must be both rigorously interpreted and meaningfully lived. In the years that followed, the number sign "My Hood is America" movement inspired grassroots initiatives to increase voter registration and civic engagement in underserved communities. Lawmakers and judges alike began to speak more openly about the need to bridge the gap between legal theory and lived reality. And in classrooms, community centers, and courtrooms across the country, Americans began to see their hoods, their neighborhoods, their stories, their lives, as integral to the constitutional promise of "We the people." The confrontation, once a flashpoint of division, had become a beacon of hope, a reminder that even in the most polarized times, dialogue, respect, and a shared commitment to justice could light the way forward.